Appeal in the matter of Olsten Holding Limited and Adeco Group European Works Council.
Ladies and Lord, good morning. I appear with Mr. Way on behalf of the appellant. Mr. O'Dare appears for the respondent's appeal. The order of my submissions I propose as follows. After a short introduction, I will deal with the context, because this is effectively a contractual construction of the meaning of transnational in the EWC agreement. And the context, we say, as you see from the skeleton, the factual matrix is the directives and the regulations which the agreement is made to implement. So we'll look at the words of the directive and then look at the words of the EWC agreement. What do they say? What do they mean? Then I'll turn to the facts of this case and the request made by the European Works Council in this case for consultation over what it thought was a transnational issue caused by COVID and Adecco's response to that. Then we'll turn to the decisions under appeal, look at the CAC's decision, its findings and conclusions, why we say they are not right, and the EAT decision and conclusions, why they repeat and compound the CAC's error. And then finally some submissions on, as far as they aren't covered already, the correct approach, the previous CAC case law about what transnational is and means, examples of things that are properly national and properly transnational, a short reply to the submissions of Mr. O'Dare that I haven't covered earlier, and then just the practical reality of what this means for EWCs and multinational companies.
Thank you. That's a long list. Have you discussed sharing the day out with Mr. O'Dare in terms of timetable?
I haven't. I had anticipated that you would want us to both have finished by shortly after lunch to give a lot of this afternoon for you to consider and determine. So I was going to take about an hour and a half this morning, perhaps 2 hours if I'm... it's a long list, right? It's
a long list. We have done a lot of reading.
And the issue is, I say...
Well, it's a narrow
really
issue of construction, and actually we can deal with that question of construction as well as the CAC and the EAT. I'm not sure you need to spend that much time on those decisions. It's a question of construction.
It is, although Mr. O'Dare relies on the fact that the CAC is a specialist tribunal, and therefore I want to point out that other CAC chairs have come to the opposite conclusion, this CAC chair.
But at any rate, we'll finish comfortably within the day. That was my concern.
Very much so. One day, including time for consideration.
Well, that would be even better.
Things. I don't know, Mr. Dare, I don't think it doesn't tend to spend a long time.
Well, Mr. Burns, if you're only going to be 2 hours tops, that'll leave ample time for Mr. O'Dare.
I mean, if it insists, having done a moderately substantial skeleton argument, I intend to be very brief.
Thank you.
And my skeleton is not the most skeletal document, as you'll have seen.
Good. So, on we go. Thank you.
The Adeco Group is, in essence, a global provider of temporary workers and a recruitment agency of permanent workers, also provides HR, digital outsourcing services. It works in 60 countries around the world, but for present purposes, it's the 21 in EEA states and Switzerland and the UK which are important. And you'll have seen that the group headquarters is based in Switzerland. It's the largest provider of temps and recruitment agency for permanent workers, I think, in the world. And in the UK, it's a large recruitment agency, again, supplying temps and permanent workers to UK businesses. And the UK at the time, not anymore, but the UK at the time was the representative agent for the purposes of European Works Councils. Since Brexit, it's been moved to Ireland because the representative agent can't be in the UK anymore, for obvious reasons. The dispute that causes the complaint to rise is about redundancies in 2019 and 2020, as the EAT noted. You will see in the figures about 33 in Sweden at the end of 2019, beginning of 2020, 75 in the Netherlands in February 2020, 9, although I think only fewer than that actually were dismissed, in Hungary in May 2020, another 30 2 in Sweden at the end of that month, end of May, and then 260 in Germany in June.
And just for my interest, a collective redundancy that requires information and consultation in the UK requires a minimum of 20 people affected, 20 employees affected. Are there EU minima?
No, and in other countries it's much smaller, 2. So some, in Hungary, for instance, it wasn't under Hungarian law a collective redundancy, but it was in the other countries. But the number of redundancies which trigger collective redundancies does vary from country to country as is permitted. But the numbers involved here, plainly out of the nearly 40,000 full-time employees, that's not the temps or the permanent people, of course, that Adecco are the customers, that are the actual employees of Adecco itself. 18,000 of those in the EEA countries. So those are the scale of the problem that we are discussing today. And the complaint effectively is whether the Swedish and the German collective redundancies were a transnational matter when taken together. The CAC found that they were a transnational matter because the CAC found that it was irrelevant that they were separately formulated in different countries in light of what the CAC were unrelated national circumstances. So the effective question is whether 2 completely unconnected events concerning employees in 2 different countries, which of themselves only have domestic effects and no cross-border effects, can be effectively added together to produce a transnational matter for EWC consultation and information if they happen to be coincidental in time.
So the connection is a temporal one?
Yes.
And that's the connection in the directive? There's a temporal, or at least in the agreement?
No, the temporal connection comes only from the CAC decision.
Okay.
Effectively, CAC said because the last few Swedish redundancies overlapped with the first beginning of the German consultation, then the 2 could be taken together. The dispute effectively is where does the boundary lie between the sphere of influence of the national consultation bodies in Sweden and in Germany and the transnational consultation body, the EWC. I'll then turn to the EWC directive as the factual matrix, the essential background context to which the agreement needs to be construed. And I say that because, as you will have seen in the beginning of the EWC agreement, perhaps if I just take it to you in the supplementary bundle, at page 2, you will see that the preamble to the EWC agreement said explicitly what you would expect, which is that it's made in accordance with the directive 97/74 EC and 2009/38 EC and the regulations, the 1999/323, the Transnational Information and Consultation of Employees Regulation 1999 as amended. On the 11th of December 2013, the parties established a European Works Council for effectively informing and consulting the Adeco Group employees on transnational matters and entered into an agreement on the AEWC, the previous agreement. Now the parties have decided to amend and restate the previous agreement by this agreement. So there's the central background. It's there to implement the regulations and the directive. So let's look at the directive. It tells us both what the background to the agreement is, but also helps to inform us about what EWCs are, because I know that although I've spent a little time doing EWC litigation, it's a slightly niche area within a niche area of information consultation within the area of employment law. The directive is at the authorities bundle at the beginning. We start at page 2, and you will have seen from our skeleton that since the 1970s, the UK and other EEA member states, I say other countries that are now within the EEA have had domestic national consultation obligations about domestic business proposals. That was very common. But until the 1990s, there were no international consultation obligations. And in the 1990s, it was recognised by the EU that decisions were being taken in Belgium which were affecting the workers in France. And the fact that the French workers had a right to consult the French business didn't really help them, because the French business were just doing what they were told by the Belgian decision. And therefore, the workers actually were losing their right to be heard, because the decision effectively had already been taken in Belgium, and it was too late to start the consultation. Consultation needing to start at a formative stage when a proposal hasn't yet reached a decision time, at a time where the employer can take into account any feedback in the consultation and then consider it before they make a final decision. And so it was realised in the single market, as companies were taking decisions in one country which affected others, you needed more than just national consultation. Hence the original EWC directive, which was then restated in the one that is in the bundle. And you'll see that effectively recital 7, it's necessary to modernise community legislation on transnational information consultation of employees with a view to ensuring the effectiveness of employees' transnational information and consultation rights. Recital 9, this directive is part of a community framework intended to support and complement the action taken by Member States in the field of information and consultation employees. The framework should keep to a minimum the burden on undertakings or establishments whilst ensuring the effective exercise of the rights granted. Pausing there, I say that's very important, because an employer, a multinational, should not have to consult two bodies over one thing if it's appropriate to consult one body about one thing and one body about another thing. The directive is clear that it's to keep a minimum the burden arising from this. So it shouldn't be unnecessary.
It's a balance. It's got to ensure the effective exercise of the rights.
Something that is truly transnational needs to be consulted transnationally. Something that is only national doesn't, is what I would say. And number 10, over the page, 3, the functioning of the internal market involves a process of concentrations of undertakings, cross-border mergers, takeovers, joint ventures, and consequently a transnationalisation of undertakings. Skipping down, undertakings and groups of undertakings operating in 2 or more member states must inform and consult the representatives of those of their employees who are affected by their decisions.
Sorry, where are you reading from now?
The end of recital 10.
Oh, yeah.
Recital 11, procedures for informing and consulting, as embodied in legislation or practice in the member states, are often not geared to the transnational structure of the entity, which takes the decisions affecting those employees. This may lead to the unequal treatment of employees affected by decisions within one and the same undertaking or group of undertakings. That's the point I was making a moment ago. Decision already taken overseas. Recital 12, appropriate provisions must be adopted to ensure that the employees of community scale undertakings, skipping on, are properly informed or consulted when decisions which affect them are taken in a member state other than that in which they are employed. So there's the paradigm case. A decision which affects employees in country B, which is taken in country A, where if there's no transnational consultation, those employees do not have an effective right to be heard. Recital 13, in order to guarantee employees of undertakings, or groups of undertakings, operating in 2 or more member states are properly informed and consulting, it's necessary to set up European Works Councils or other procedures. Recital 15 is important. Workers and their representatives must be guaranteed information and consultation at the relevant level of management and representation, according to the subject under discussion. To achieve this, the competence and scope of action of a European Works Council must be distinct from that of the national representative bodies and must be limited to transnational matters. Now, that recital is at the heart of my case. I say that where Adecco Sweden decided for reasons relating to the Swedish economy to do something, and entirely coincidentally, overlapping by a few days, Adecco Germany decided to do something because of a change in the German law and some other reasons. Adecco Sweden is going to consult Swedish trade unions and consultative bodies. Adecco Germany is going to consult German bodies and representative bodies. And we have a decision here of the CAC and Mr. Justice Kerr in the EAT, which means that there is now no distinction between the scope of the EWC and the scope of the national bodies. And I say that the scope has not been limited to transnational matters. Transnational matters has now been included to national matters, which just happen to take place at the same time.
Burns, would you normally expect on your argument that it's one or the other? It's the your EWC or the national body?
No, because
you do accept that there
something
are
that is generally transnational.
Yeah. Would tend
has
to engage
impacts
both.
and as consulted, but then there will be the trickle down. There will have to then be national consultation about how it affects that particular country. So the transnational consultation is about how it affects two or more countries, or the group as a whole. And the representatives in the EWC can actually give information to the national body to say, well, this is happening over in Sweden.
Yep.
The same thing, the same consultation, or the same pledge of redundancies. They're getting a better deal than we are. And so you should be arguing, why don't we get what Sweden are getting? Because this is the same decision, same proposal, and we're getting a thin end of the wedge. That sort of thing. Or we are closing the plant in Sweden, and we're going to be moving the operation to Germany, and the EWC find out about it because it's a transnational issue, a proposal which affects both Sweden and Germany, and the EWC consult, and then the Swedish people who may want to object to the closure have the ammunition. Possibly the German representatives are happy about this deal, and so they're not going to take an objection. But yes, there's
So if it's
trickle down.
genuinely a transnational issue,
Yes.
you would typically see both the transnational and the domestic committees or bodies involved, but you say they would be performing rather different functions within that overall exercise. So it's not that it's one or the other. It may well be both, but doing different things.
Absolutely, and the EWC agreement has to link the national and transnational consultation in order to avoid it being unduly burdensome. So,
Whilst ensuring that the interests of the employees are
yes,
protected.
and the linkage comes in recital 37, I think. I'm told 21 and 20, yes, so 21 and 29. So 21, it's necessary to clarify the concept of information consultation in accordance with definitions in the directives, with the objectives of reinforcing the effectiveness of dialogue at transnational level, permitting suitable linkage between the national and the transnational levels of dialogue. And then 29.
And ensuring legal certainty.
Yes. So that effectively, the boundaries are set out in the agreement.
Yeah.
And that paragraph 20, recital 29, such agreements must lay down the arrangements for linking the national and transnational levels of information and consultation. So you've got these, so the linkage stops the duplication being burdensome, because the EWC agreement has to, under the directive, show how those two things will be done in tandem or in parallel. Just going back to page 3 of the authority bundle, we got to recital 16, and here's the classic definition, which we see here, we see in the regulation, we see in the EWC directive, in the EWC agreement, and we see it in other of the EWC cases in the CAC. Recital 16, the transnational character of a matter should be determined by taking account of both the scope of its potential effects and the level of management and representation that it involves. For this purpose, matters which concern the entire undertaking or group, or at least 2 member states, are considered to be transnational. These include matters which, regardless of the number of member states involved, are of importance for the European workforce in terms of the scope of their potential effects, or which involve transfers of activities between member states. So it's transnational is determined by taking account of the scope of its effects. Does it have an effect in more than one country? Does the proposal have an effect in one country only, in which case domestic, or does it have an effect in 2 countries or more, in which case transnational? The level of management and representation involved. Is this a proposal which is a European-wide proposal? European level of management, in which case likely to be transnational? Or is it a proposal which is domestic? It's a proposal of the domestic company, in which case national only. And we see that something that includes the whole group, and within Adecco, there are things which could affect the whole group. For instance, Adecco globally has a well-being policy. All countries have to sign up to make sure that the well-being of employees is met to a minimum standard, obviously up to individual countries to how they implement it. Every country has to have a flexible working policy. Again, up to each country how they implement it, but it's a transnational matter which comes from the centre.
You're spending a lot of time on the recitals, which is obviously relevant, but when we get to the actual directive,
Yes.
paragraph 4 is actually quite much narrower than the recitals reflect. So what's the status of the recitals in terms of interpreting Article 4?
The answer to that
or Article 1.4
is Olympus. Skip on quickly, we can deal with this very quickly. Page 127 of the authorities bundle. Paragraph 47 should be sidelined. And it goes on to paragraph 48 and 49.
That's about the actual articles, isn't it? That's not about the recitals.
So the meaning of the article
Yes, is informed
yield
by-
to the purposive approach,
Okay.
which can be taken from that, and then allied wallet,
Okay.
which is I put the flag in the wrong place. It's at page 266 of the authorities bundle. Tells us, as you'll see there, recitals are not legally binding, however, as confirmed by, I'll leave you to read that by yourself.
Yeah.
So I've gone through the recitals because this isn't actually about what the article of the directive means, because we're not actually enforcing the Article 4, Article 1.4. We're actually enforcing the agreement. And the question is, well, if there's any ambiguity about what the words of the agreement mean, they need to be construed in the basis of the Investors' Compensation Scheme, Chart Book, Arnold Britton, all those, the factual matrix, the essential factual background of which the parties are taken to be aware when they make the agreement, and that is the directive, the purpose of the directive, making the directive effective. It's about interpreting the agreement to make information, transnational information and consultation work, and not make it burdensome because you're including purely national matters and making you consult unnecessarily with the EWC as well as with your national bodies. But yes, you're right that on page 6 of the authorities bundle, Article 1.4, well, Article 1.3 first of all, repeats what we see in the recitals, that about competence, information consultation must occur at the relevant level of management representation. I've told you about that already. According to the subject under discussion, is it international management, is it national management? To achieve that, the competence of the EWC and the scope of the information and consultation procedure for employees governed by this directive shall be limited to transnational issues. What matters shall be considered to be transnational where they concern the community scale undertaking as a whole, or at least 2 undertakings or establishments situated in 2 member states. So if we have a proposal, this is the case at its simplest. We have a proposal by an employer to make redundancies. The question is, does that proposal concern Adecco Group as a whole? If not, does that proposal concern at least 2 undertakings within 2 different states? If not, that proposal is a national proposal and falls outside of the agreement because it's not transnational.
But you could have a proposal to make redundancies in Belgium that will reduce the workforce, that could have effects in Luxembourg, let's say, because there are employees in Luxembourg who might have been employed much later and who could be made redundant instead of the Belgian employees. And so the mere fact that the proposal affects Belgium doesn't necessarily mean that transnational issues aren't engaged.
In your example, that proposal affects Belgium and Luxembourg.
But that might only arise as a result of having provided the information. That the possibility of the effects may only occur.
The employer will know that it has employees in Belgium, but it shares some services or some with Luxembourg.
But the employer may be determined to keep it in Belgium.
Yeah.
And the unions may want to say, well...
Exactly. And so in that circumstance, that is plainly transnational. And that's the submission I made to the EAT.
Well, is it plainly couldn't the employer argue on your argument? It's not.
No.
We're only dealing with this locally. We're limiting...
No, because the 2 would be related. What happened in Belgium and what happened in Luxembourg would be related, be a connection between the 2. And indeed, you've seen in the directive recitals, it's about effects, where a proposal has effects in 2 or more countries. Back to recital 16. The transnational character of a matter should be determined, taking into account both the scope of its potential effects. And in your example, the Belgian management, it may be taken at a national Belgian management level, but the scope of its potential effects are Belgium and Luxembourg. And the proposal would have related effects in Belgium and Luxembourg. The CAC here said it doesn't matter, it's relevant if what happens in Belgium and Luxembourg are unrelated. I said that's just crazy. Of course they must be related. Of course it must be something that affects both Belgium and Luxembourg. If what's happening in Belgium and Luxembourg is completely unrelated and unconnected, then that's just 2 national decisions being taken by Belgium.
Would have been very easy to include those words, though, that there must be some relationship in paragraph 4.
But paragraph 4,
it just says...
It's plain, is it not, my lady? A matter is transnational where it concerns at least 2 undertakings situated in 2 member states. So the concern is the causation word. So the only question for this CAC is, does this proposal concern 1 country or 2 countries? And in your example, the proposal concerns 2 countries because it has knock-on effects. Now, what Mr. Justice Kerr said in the EAT is that he in order to explain his decision, he said that inevitably there'd be knock-on effects. But that's just not. There's no evidence of that. That wasn't this case. In fact, this was the opposite of this case. CAC found there were no knock-on effects. They were unrelated. And of course, lots of things happen in the UK which affect only UK employees and have no knock-on effects at all. It might be that something happens in Manchester, we close a base in Manchester, and that has knock-on effects in Newcastle. But there'll be lots of times where it doesn't have international or transnational effects. There will be some. Car plants we've heard about, where a car plant closes in the UK because they're thinking of moving the car production to Romania. Now that plainly has transnational matters. But to say that it's inevitable, it's always going to be transnational, that is industrially nonsense, unfortunately, because there's lots of things, especially in a big employer country like the UK or France, where things will happen entirely internally.
Can I just ask a question on that point, because it was part of Mr. Justice Kerr's reasoning. You're looking at obviously the causes, but sometimes the solutions may be transnational. So, for example, at the European Work Council, the employees might say, well, look, we managed to save a lot of redundancies in Netherlands by using the COVID parachute payments. Why don't you think about that? And the budget, and I think this is really what Mr. Justice Kerr was getting at, the budget is set by the Swiss company for the UK, if the redundancies are in the UK, and they say, well, why don't you increase it and use a bit of the reserves? And that might also save the situation in Germany. And that's what I had read or misread his judgment as suggesting the international effect. And that's why using the language as it reads doesn't do violence to the intention of the directive.
So there's 2 things there.
Of course.
First is that the international budget for workers throughout the group is a transnational issue. And that will come up at the annual meeting. And every EWC has to have an annual plenary meeting at which not these special events. Special events are collective redundancies, acquisitions, and relocations.
Yes.
And those require an extraordinary meeting because of something. But it's expected, of course, that every year the company will talk to the EWC about how it's doing globally. And at that stage, my lord, of course, the EWC can say, well, why aren't you helping or putting more resource in this country rather than that country? But that is provided for. And but what Mr. Justice Kerr can't do is then use that as a way to change what goes on at an extraordinary meeting. Now, if it's right that every national proposal to relocate a site or to acquire a business or to make some redundancies, in theory, could be argued by the unions to say, oh, well, don't do it in that country because of this country over here. Then, of course, all of those events, every acquisition, every relocation, every redundancy in every country would have to be brought before the EWC.
It would have to concern at least 2 states, though, because that's the
Not on this theory, because of course,
on the
in
wording,
theory, there'd be a knock-on.
No, but on the wording of V14,
yes,
it would have to, because the special circumstances or decisions that are engaged include, by definition, only collective redundancies which significantly affect.
That's page 12 of the supplementary.
So
that's exactly my argument.
well, it isn't. That's in the definition section. So your answer to my lord's question is it would be extraordinary, but that's not the world we're in, because there's a limit to clause.
Yes,
by
there is absolutely
1.4.
that the wording of the extraordinary meeting provision prevents
Yes.
the union saying, well,
Yeah.
this purely domestic proposal we want to look at this purely domestic proposal in case we can argue. Answer no.
So if it isn't a purely domestic proposal, as my lord has suggested, and it has potential effects or solutions that are transnational, what's so hard about organising an EGM?
Well, a company does need to in those circumstances. That was my submission below. That's my submission here. If two things are generally connected, if Sweden and Germany in this case had been related in some way, there'd been some relation.
Who decides if they're related? Because the union might think that they're related, and might think that there are related solutions, as my lord has put to you. Why then shouldn't there just be an EGM to say either yes, we can see your point, or no, these are totally unrelated and the solutions are unrelated, and that's
So the
we've
relationship,
given you the information and that's the end of it. It's not that.
it must be an
cumbersome.
objective test. The proposal must either be a proposal which concerns two countries, or it's not, or the proposal doesn't concern two countries. It doesn't matter what the union think or union might want. It's not a subjective test. The question, it's an objective test. Does the proposal in fact concern employees in two or more countries? Because otherwise the unions would say, well, everything might do, so we'll have EWC consultation about everything, please.
But isn't this what Mr. Justice Carr was really concerned about? Because it's very easy to get out of this if you say we're the employer, we decide, and we've done a proposal that only concerns Belgium, and that kind of begs the very question, doesn't it? Because if this is all about giving information, it may very well be that the workers come back well, it's not just Belgium actually, it's Luxembourg as well that's involved here.
Well, and the answer to that is that it's answered by, it's a question of substance.
Okay.
Is it correct
Yeah.
that and in fact, I'll take you, I was going to take you to this in a moment, but I'll take you to what has just been, I think, been published in the last few days by Harvey about this, which comes to this exact conclusion, that it doesn't matter what the employer thinks or the union thinks. The CAC should be looking at this as a question of substance. In substance, is this a proposal which does affect two countries, or in substance, is this a proposal which is proposal over here which is unconnected, unrelated to the proposal over here? Now, when we looked at Harvey for the purpose of putting together the authorities bundle, it still had its 2 paragraphs, which it's had for the last 15 years, saying nothing more than the directive. But at some point since then, and we only spotted it last night, so I apologise for that. But I think it's...
Who wrote it? Who writes Harvey now?
It's
not you.
Professor Smith.
it's
A
not.
bit self-serving.
It's not me. No. It's Professor Warnock writes the section on. If I can have
This one.
On.
Thank you. Excuse me, Associate. Can we possibly have these documents?
Thank you very much. And sorry, just to ask questions, just so for my note, when did this come? Was this added?
This case, I
I know you saw it last night.
I served last night, and we told Mr. O'Dare that it was here, and so printed it off this morning for the court. But I don't know
when it went in.
because online. It's an online publication.
No.
So it's
just
the last
updates.
update.
Whatever.
We don't know when that is.
Okay, thank you
But
very much.
the EAT decision was only reported in the IRLRs in, I think, April, and so presumably after that. So what Harvey says is this. First of all, 652, the intention is that the information consultation could cover at least those transnational questions which significantly affect the workers' interests. TISA, which is the UK regulations, confines transnational matters of exclusively national concern should be dealt with under the ISA instead, as those are the national information consultation of employees regulations. Where there's an overlap, for example, where and that's the community scale undertaking, decides to close a factory and shift production to another relevant state, there should be some appropriate linking mechanism. question is transnational for this purpose if either it's a matter which concerns the MNE, the forget what Professor Warnock's acronyms for, multinational enterprise, I think.
Yeah.
But it's in order to avoid saying community scale undertaking or groups of undertaking, which concerns, as the causation word, at least 2 undertakings or establishments situated in 2 different member states, and refers there to the directive and to the wording of the regulations, and refers to Haynes and British Council, which is earlier in the authority bundle. The CAC has held that concerns means relates to or is about and need not involve any element of potential adverse effect on workers. Consequently, a proposal to close a factory in the UK and move some of its production to Italy, where it would result in a proportionately small increase in work, was a transnational matter. Prince's Group, European Works Council, and Clegg, and the central management of this Prince's Group. In Olsten UK and Adeco Group, the AT pointed out that redundancies in one country could have knock-on effects in the workforce in other countries, and thus be transnational. That part I would accept. In Verizon, EWC and Verizon Group, one company with a group employed 183 people in North America, 2 in the UK, 1 in each of Germany and Spain, and the CAC held that a proposal to sell this company was a transnational matter because of the 4 EU employees across the 3 EU states. The next part is important. This is the commentary, effectively. There is scope for avoidance tactics. Suppose the management of Devious International proposes to shut down both its Spanish and its Portuguese operations. The proposal is clearly a transnational question within the definition. But it's supposed Devious, adopting the so-called salami tactic, proceeds sequentially. Initially, it proposes to shut down Spain alone. That looks like a national matter and not a transnational matter. But having shut down Spain, Devious proposes to shut down Portugal too. Can Devious legitimately claim that Portugal is merely a second national proposal? TISA, like equity, should look to the substance, not to the form. If, in truth, the 2 proposals are linked, then they should be treated as a single transnational question, attracting the need to inform and consult under the regulations. Reliance may be placed on Article 16 of the directive, which indicates that a broad approach is appropriate. Pausing there, if the 2 proposals in this case, the proposal in Sweden and the proposal in Germany, were linked in any way, then plainly we wouldn't have an appeal. The appeal is because the CAC found that they were not linked and yet they were transnational.
It's not, no, but it's not linked, it's potential effects, isn't it? If
Yeah.
they had, they could be unlinked, you could have a devious employer who would deliberately unlinked them. If they had potential effects that crossed over.
Exactly. In this case, on the facts, they're unrelated. That's what the CAC found.
But we're also in an environment where these nice legal arguments need to be capable of certain determination at an industrial collective negotiating level.
Yes, and indeed, at that level, if the EWC reps from Spain and Portugal are talking, which they of course will be, and they find that Devious has closed Spain, and then after it's closed, they will go and say, well, was this a one?
But they can't wait for the CAC to determine it. They need the information if it does potentially have effects.
Yes.
There needs to be a workable interpretation rather than
Yes,
a cumbersome and
I think what
difficult
Professor Warnock's
interpretation
saying,
that requires us to go behind.
but I think what Professor Warnock is saying is if an employer tries to hide it in this way, that won't work, and the CAC will find that they were linked, they were part of the same proposal, they should have been consulted at the beginning of Spain, and there will be a finding of breach, and there will be a potential penalty to follow. Therefore, there is a big stick. Employers must consult when they're proposing Spain and Portugal at the outset, and therefore it's workable. So it's effectively an objective test suggests, and we obviously look at Regulation 16. Milady, you said negotiation. Negotiation would only be
Yes, sorry. Yeah, I meant
national.
information. I meant information.
Information consultation is
Yes.
transnational.
Yes, sorry.
Then Professor Warnock considers a Belgian case, which is a matter of Belgian law, where actually which is Olsten and BA Group, where I haven't cited that because the wording in that EWC agreement is it needs to have cross-border effects, which was not. I would say it has the same eventual meaning, but I didn't see that a case in Belgian law which had a different wording was going to be of much assistance to my lady.
You might find that the agreement that's entered into, for so long as it complies with the minimum requirements of the directive and the regulations, actually provides for something slightly different in a particular employer's case.
Yes.
So these special events and circumstances in this agreement have been interpreted as meaning transnational effects. That's a different. We're in a different arena than we would have been had transnational effects had the meaning set out in the directive and the regulations, but as applied to the particular circumstances or decisions.
Yes, but this agreement effectively uses the exact words of the directive to define what is transnational. We'll come to see.
Well, let's see.
And then finally, 65205, Harvey deals with this case in the EAT. Perhaps I'll just let you read that paragraph to yourselves.
So Harvey says to some extent the reasoning depended on the particular wording. And that, if that's right, then it doesn't affect every case, it just affects this case.
But as the wording in this EWC agreement is taken directly from the directive, it would be difficult to see how
you
it
say
wouldn't
it
affect.
isn't. You say it doesn't depend on the
I think
particular wording.
Professor Warnock is probably trying to, and you'll see that at the end there, he says it's submitted that whilst it might be true, it cannot have been the intention of the legislators that EWC consultation is required every time there is a proposal for some redundancies.
But whatever the intention of the legislators, if the company and the unions agree an EWC agreement that says something more, that's what we have to.
The EWC agreement, if it means something different from the directive and the regulations, then of course they could gold plate it. But as I'll show you, well, I'll
You say it
show you
doesn't.
next.
I understand.
Harvey says it can't be the intention of the legislators that proposal redundancies in more than two countries for what might be wholly local reasons. And then obviously it notes that this is under appeal. So that takes us to the end, and I can take you very briefly to TISA. We don't need to look at it more than a paragraph.
So before we close the directive, it's just Article 1, subparagraphs 3 and 4 and the recitals that you rely on. There's nothing else in the directive.
Nothing else in the directive, no. The rest is about the mechanics.
Yes.
And then TISA
And do we need to look at the regulations before we...
Just
Oh,
page, just page 23. And obviously these regulations are now much cut down post-Brexit, and most of them have been deleted. But paragraph 4A on page 23, you'll see the exact wording is taken from the directive. Matters are transnational where they concern the community scale undertaking as a whole, or at least two undertakings or establishments of the community scale undertaking situated in two different, now it's relevant states rather than member states.
So that's Article 1.4 replicated.
Article 1.4 replicated. Exactly.
And then you close, because there's also the what's it called, an annex or something, a schedule with subsidiary requirements under Regulation 18.
Yes.
And paragraph 8 talks about exceptional information and consultation meetings. And the
Yes.
exceptional circumstances are defined by reference to or include collective redundancies.
Yes. So where a
Page
special
90.
negotiating body and the undertaking fail to reach an EWC agreement, after 3 years, automatically the subsidiary requirements
Oh, those
come
are
into effect
okay. I see.
as a backstop.
I see.
Uh,
Okay, so
and-
but where you've got an agreement, that's fine.
When you've got an agreement, the Regulation 18 and the schedule don't need to come into force because they are effectively autonomy of the parties.
Yeah.
It's respected. So next to the EWC agreement, and we look at, well, what does it say and what does it mean? I've taken you to page 4 already.
Sorry, can I just ask,
Sorry,
where did you
page-
say 4B came from? 4.
4A.
4A on page 23 is the same wording as Article 1.4 of the directive.
Right, yeah.
Effectively, what in,
Yeah.
in transposing the regulations into English law, they've taken it almost word for word from the directive.
Yeah.
So starting at page 2, of the core bundle, of the supplementary bundle, I've taken you to the preamble already, which shows that the agreement is to put into effect the directive and the regulation obligations to inform and inform and consult.
So which paragraph is that?
That's preamble, page 2.
Yeah.
The next I would take you to is page 3, second paragraph. What's the purpose of this agreement? The purpose is to promote the social dialogue at European level within the company without encroaching upon the purview of national representative bodies and without questioning the group's adaptability. I'm just going to. I don't need that word, so I'm going to ignore it. So the crucial thing here is that the agreement says that it's to promote European level, which is a proposal which affects more than one country. Because anything that affects 2 countries, any proposal that affects 2 countries is at European level, and without encroaching upon national representatives. And the trouble with what the CAC have done and the EAT is it does encroach. It effectively takes, it means that the EWC has to be consulted as soon as possible by the business, rather than it being solely the responsibility and of the national representatives. Effectively, it's a bit, one might think it's a bit of a turf war between the EWC reps and the national reps. But the agreement is clear, they mustn't encroach. Objective number 1 at the bottom of that page, page 4, based on the experience considering the directive, the present agreement aims at establishing the Adeco Group European Works Council for the purpose of informing and consulting the Adeco Group employees within the geographical scope of this agreement. Once again, scope is set out. What is the scope? We turn over the page. We see at number 1, the parties must collectively represent the interest of the employees of the Adeco Group at European level. Again, I say it couldn't be clearer than this. It's the level of the agreement, and this applies as much to the extraordinary meetings as it applies to the annual meetings. It's European level matters. It's complementary to and distinct from the national systems.
But that's not the scope. That's just what they should do. The scope is at 2, isn't it?
Yeah, it is. It is. So, and that obviously headed scope, the agreement extends to companies, future companies of the Adeco Group in the countries that are part of the EA, the United Kingdom and Switzerland, which Adecco, which subsidiaries operate. Here's the crucial wording, which I say answers the whole question in this case. The information and consultation within the Adecco EWC shall be limited to transnational matters.
Yeah.
Transnational matters are considered as transnational where they concerned or have potential effects at least on 2 undertakings of the group situated in 2 different EEA countries on the community scale group of undertakings as a whole. and correcting it as the EAT does, that should say matters are considered as transnational where they concern or have potential effects at least on 2 undertakings of the group situated in 2 different EEA countries or on the community scale group undertakings as a whole. And with those 2 corrections, you'll see that it's exactly the regulations definition and it's exactly the directive definition. So they've just taken the directive scope and they've copied it slightly with typos. But a matter, a proposal, is transnational. So let's just take this case. The Swedish proposal is transnational if it concerns or if it has potential effects in at least 2 undertakings situated in 2 countries. The Swedish proposal did not have, as the CAC found, did not concern any other country, just concerned Sweden, did not have potential effects in any other country. It only had potential effects in Sweden. It was unrelated, said the CAC to the German ones. So the answer, and effectively the CAC and the AT, to a certain extent, kept on looking at the extraordinary meeting provision and said, well, I hadn't answered the question about why. But you don't even get there because the scope of the whole agreement is defined by paragraph 2. It doesn't even get into the agreement at all unless it's a transnational matter. The Swedish proposal does not even get through the door of the agreement unless it concerns another country other than Sweden or it has a potential impact on another country other than Sweden. The German proposal too. The German proposal only was unrelated to the others, said the CAC. And that's the answer to the case, in a nutshell. But we can see that the agreement scope is to number 1. Effectively, I say this is belt and braces for me. Issues which relate to 1 or more undertakings in 1 or more participating countries. So there we are, issues, if there was an issue which related to 2 countries, which relate to day-to-day management, remuneration, compensation, benefits, terms and conditions of employment. And then here's the important one, staffing levels of the single country and other issues of similar kind will be excluded from discussion under these procedures as they are to be dealt with specifically through local or national information and consultation arrangements. So, an issue which relates to the staffing levels of the single country is excluded from the whole agreement and is reserved to the national bodies. The Swedish proposal only related to the staffing in Sweden, as the CAC found. It didn't relate to the staffing levels in any other country. The German proposals related to the staffing levels in Germany and no other country. And the AT had to, in order to overcome this, say, oh, well, staffing levels means the number of employees who were employed at the beginning. But that can't be right because an EWC agreement is agreed at a time when there's already employees in various countries. It's about the changes to staffing levels, about whether staffing levels go up or go down, whether you recruit by an acquisition or you shed by redundancies.
So that would apply even if you're reducing your staffing levels on your arguments by a collective redundancy agreement. It could be a lot. You could be closing the whole office.
You could be closing the
Get
whole
rid of
office
everybody.
in Germany,
Yeah.
but as long as you're only closing the whole office in Germany and it doesn't affect anybody in any other country, that's something that the German national representative bodies will be all over. But it's something the EWC reps will say, well, it's nothing to do with us because it has no European dimension. This is purely a German proposal which only affects German workers. So I say that scope, and I say something on the ordinary and natural meaning of the words, it means that. But if you take those words and put them in the context of the background I've just given you, the directive, it's absolutely clear that there must be a clear delineation between national and transnational, and that something that only a proposal which has an effect or a potential effect in 2 countries And these Swedish proposal and the German proposal, as the CAC found, had neither. They just happened to happen at the same time. They were the only way that they get over the line. The two entirely unrelated proposals just... So on the CAC's decision and the AT, if they'd happened a week apart, then you wouldn't have taken them to the CAC. You wouldn't have taken them to the EWC. So if there'd been 5 days between them. But how can that benefit European information consultation? Why does it matter? Why does it go to this EWC if they overlap by 1 day? It doesn't go to the EWC if they don't overlap by 1 day. The question must be, is there a European dimension to this? Is there a transnational dimension to this? Which means that the transnational body can give its opinion, not timing. Timing is irrelevant to it. It's, as Professor Warnock says, it's the substance of whether they actually are linked, they actually are related in some way. And so that's why when you get to, on page, well, I'll just look at page 10 first of all, of the supplementary bundle, the EWC agreement at 4.3, the EWC and any local level information consultation shall run concurrently and shall not delay or impede the other's progress. That's the linkage that Lady Justice Whipple asked me about earlier. Number 5 talks about the annual meeting, and that's the one that my Lord Justice Dingemans asked. The budgetary matters and so forth will be part of the annual meeting, and other matters which are transnational. But what we have in this case is 5.1.4 on the bottom of page 11 is what the CAC and the EAT got wrong, I say. Extraordinary meetings will be convened to provide information.
Sorry, before you deal with it,
Yes.
is there an obligation to have extraordinary meetings? Or is this something that this organisation decided it would like to do?
Yes, it's in the subsidiary requirements.
It is
as
a
you've seen.
subsidiary requirement.
So because it's in the subsidiary requirements,
They
it's
have
feature.
yeah.
Well, it doesn't. They don't have to.
No, but if they don't, it will be implied by virtue of Regulation 18 and the schedule.
Strictly not. What happens is that the SNB and the employer have 3 years to negotiate.
Right.
The employer and the SNB know that if they don't reach a deal, then the subsidiary requirements will come into effect. Therefore, most EWC agreements that are agreed do include either the features of the subsidiary requirements, or they gold plate them to some extent,
Yeah, okay.
or they adapt them for their business. But it's unlikely that the union would agree to something that was a lot less than the subsidiary requirements, unless there's a particular circumstances.
Thank you.
So it's a common feature, is what on that basis. So extraordinary meetings on the following transnational issues. We know it's got to be transnational issues because that's within the scope, as I've shown you a bit before. It's not within the scope, doesn't even get to clause 5.1.4, and that's why in the event of collective redundancies which significantly affect existing Adecco employees in each of at least 2 EEA countries in which Adecco has employees, I say again, that means what it says. An employer has a proposal for collective redundancies. Do you need to consult the EWC on that proposal? You do if that proposal significantly affects Adecco employees in 2 countries. You don't if that proposal significantly affects Adecco employees in only 1 country.
Can we just rewind? I've got a bit. Your case is that the starting predicate is that you've got to have a transnational issue,
Yes.
first and foremost. And that's a matter of substance, and it depends on the potential effects of
Yes.
the proposal. Does that mean that you could have some transnational issues that fall outside A, B, and C on which you don't consult your European Works Committee, or is this a comprehensive definition, or it just splits into 3, the sorts of transnational issues you're going to have?
Yeah, so we could introduce a new global wellbeing policy which affects all countries. That wouldn't trigger an extraordinary meeting because although it be a global transnational issue, it wouldn't be an acquisition, a proposal for acquisition or proposal for collective redundancies or a proposal for relocation. It's extraordinary because it's not the ordinary transnational that you need an extraordinary meeting for. It's something that was unexpected. We're going to acquire a company. Nobody saw that coming. It couldn't be talked about at the annual meeting because it's sort of out of the ordinary. We've got a change in the German law, the Temporary Employees Act. Suddenly, our business model is changed in Germany. Therefore, we're going to have to change how many employees we employ. And again, extraordinary event, extraordinary. So there are more transnational issues than these three.
So that's the point. So we need to be satisfied. You'd say that it is a transnational issue before you get into the ABC. So the ABC are a narrowing of the general concept.
Yes, because of clause 2 scope. Doesn't get into the agreement, doesn't get through the door unless it's a transnational matter.
Can I just ask you one question on the B now that we've got to this, and again on just the budget issues? You rightly pointed out that that's addressed at the annual meeting where people might say, yeah, we want a bit more, we want a bit less, etc. Anyway, the employer takes its decision. But if you then have collective redundancies in Sweden and then collective redundancies in Germany, it might be that with the best will in the world, the situation has changed, there may be a war in a European country, and this needs to be reassessed. And that would be, within the meaning of these words, something that could be looked at by the European Works Council, because the budgets might need to deploy reserves for a short period. And what's wrong with that construction for an EGM? Because of course the employers are the ones who can say, well, nice idea, but no.
So, Lord, I think the answer to that is this, that in a company like Adecco, which, as the CAC found, is a company which is not centralised, it's a decentralised business. So you have the owners of the group in Switzerland, but they set, as you say, annually, group budget, group strategy, and then they're hands off. Each company can then run its, UK can run itself. UK Board of Directors has control. It isn't a company which is a centralised company, which effectively the UK Board of Directors is just doing what the central management tell it to. And that in some ways is a distinction. If you had a situation where there was a war and central management said there was a war, things have changed. Okay, countries, this is where you now need to do something because of this. That effectively would potentially be a transnational issue, because that would be the central management in country A telling countries B, C and D to do something, affecting employees in countries B, C and D, but those employees don't get a voice unless they get to the European Works Council and influence central management. Whereas in our facts, there's Adecco, if there's a change in circumstances, there's a change in circumstances. The UK management sorts out its UK consequences, the German management sorts out its German consequences, and so forth. It's decentralised, which means that there is effective information and consultation to the employees in the UK, because the people they're speaking to are is the guiding brain for the change. Essentially, what I say is that the whole point of European Works Council is to make sure that the workers and their representatives can talk to the guiding mind. And if it's a decentralised company and the decisions are actually taking place in the UK, which affect UK workers, then those employees get proper information and consultation if they can talk to the UK business at national level. If it's a centralised business, then they're denied their right to be heard. And so effectively, you could have facts where it's a centralised business and there's a change in circumstances and everybody's told in the various countries what to do, at which point the EWC would be engaged. What happened in this case is that in Sweden there were a particular Swedish circumstances, a Swedish national recession. The Swedish employer had to decide what to do about it. It was the guiding mind. It was the right person for the employees to talk to. There's no point talking to Switzerland, because they say, well, we actually don't know. We're not in charge of what's going on in Sweden, and we've got nothing to tell you about what's going on in Sweden. It's actually nothing to do with us. You have a change in the employment law in Germany, which means that the business model changed. Once again, the workers get effective information consultation if they can talk to the German works councils. They don't need to talk to Switzerland because, once again, Switzerland are going to shrug their shoulders and say, it actually wasn't us, that they did what they needed to do. And you saw that in the directive recital. It's about talking to the right level of management.
Thank you.
So those are the provisions of the... I'll just go to, finally, page 16, which you'll see the applicable law. Once again, the agreement says that it's one that's under the directive and the regulations, the linkage again, your laws of the UK, and you can see it's signed by the various different countries' representatives on page 18 and 19.
And it says somewhere that it's binding.
Yes, that matter isn't in dispute. I'm disputing what it says and what it means, not. So skipping on, because I see the time, and I want to be good to my time estimate, extraordinarily. Facts. Effectively, we've talked about most of the facts in this case as we've gone along, but just look at the supplementary bundle, page 22 and 23. And this is the request which triggered the dispute. This is the request. This EWC saying we need EWC engagement because this is a transnational issue. What does the EWC say on the 26th of May 2020? Well, it doesn't say what the CAC said or what the EAT said. It says something very different. Have a look. It says, at the steering group, we were surprised that despite it being announced several times in the Adeco Group worldwide communications that the current financial situation of the Adeco Group is overall solid and healthy, can sustain the business with strong cash flow, safeguarding jobs is of utmost importance. We've recently been informed about collective redundancies in at least 3 different European countries of the Adeco Group as a consequence of the COVID-19 crisis. So they think they're linked, they're related. These include dismissals in Hungary and large plans for dismissals announced in Netherlands and Sweden. Netherlands, redundancy plan announced, and you'll see that. Sweden, redundancy plan due to COVID-19 crisis announced. Hungary, collective dismissal of 13% of the workforce is already done on the 7th of May. In the first 2 cases, we are in front of a transnational issue affecting the workforce of 2 countries due to the announced redundancies coming from the COVID-19 crisis without the EWC being informed or consulted. So the EWC, they say, well, these 2 proposals are linked. They're linked because they're both COVID proposals. And then they say, in the case of Hungary, we're looking at a transnational decision affecting Hungarian colleagues coming from the cluster manager located in Romania. According to the hard strategy directed from the head of Eastern Europe, we'd already announced in September 2019. So in Hungary, they say, this is transnational because it's a decision in Romania which affects employees in Hungary. So the EWC have it exactly right. In theory, in their construction of the contract, just as a matter of fact, as the CAC found, they were wrong. These were redundancies which predated COVID and that weren't COVID-19 related at all, and Hungary wasn't directed by Romania. So,
So is there an answer to all of that?
the answer is at page 29, and it's the letter from Adeco Group Chief HR Officer on the 24th of June 2020, and you'll see they're apologising for the delay because they had a virtual EWC meeting on the 10th of June, which meant that there was a delay in investigating the request for an extraordinary EWC meeting. So I think the annual meeting was on the 10th of June, and they were asking in May for an extraordinary meeting in addition to the annual meeting. And you'll see, if you turn over to page 30, the second paragraph, on the decisions to let colleagues go, as shared in previous discussions, the group operates as follows. Adeco Group headquarters is responsible for developing group strategy and translating in consultation with the countries its strategic objective into local operation targets and country budgets for its business across the globe. While the overall strategy and objectives are set at the centre, local management teams must decide on how to put the strategy to work and so forth. So first of all, they talk about the decentralised nature of Adecco. And at the bottom of that paragraph, they say, unfortunately, in some cases, local management may need to consider and implement redundancies. To state it clearly, Adeco Group headquarters does not ask countries to cut jobs. It's up to each country to make decisions relating to the composition and volume of its workforce based on a series of parameters. So the first answer is we are decentralised. These aren't decisions taken from the centre. That's repeated in the next paragraph. And then on the bottom paragraph, that same page, on establishing the causal link between the loss of colleagues in Netherlands and Sweden due to COVID, it's transnational, we inform you that in both countries, decisions were taken due to country-specific developments before the crisis hit in mid-March. So they explain that over the page on page 31. In Netherlands, there's a change in Dutch law, and in Sweden, second big paragraph on page, due to a country-specific situation, a local recession. So and then they deal with Hungary on the page 32, and effectively those are translated into the findings of the CAC, which are recited by the EAT.
It's a bit muckier than that, actually, isn't it? Because what they're saying is even if it was COVID, we'd still be saying it was not transnational. I think as things have shaken down...
Happily, I don't need to have that, because that was a matter for the CAC and their findings. They could have found, actually, as a matter of substance,
it was all COVID.
These were related. And obviously, in which case I'd have no complaint.
Yeah. And this is an appeal on a finding on law only.
Yes, law. So if we go then to the CAC decision, and I'll take this fairly swiftly because this obviously is a document that you indicated that it's been read. They are in quite an unusual format where they set out at huge length the process and the party submissions and then the party replies and so forth. So if we cut to the chase, you will see, well, in passing, that the collective redundancies complaint is outlined at page 93 of the core bundle. This was where they explored the fact that the complainant said that it was COVID-19 that linked the collective redundancy proposals. You can skip over the business sales performance data complaint because that is a separate issue and no appeal arises from that. The page 102 and 103 are the detail of the CAC relating what I've just showed you was in the employer's initial response. So we don't need to look at that in detail, but the CAC took that into account. Paragraph 40, the end of paragraph 40, you'll see the example that the appellant did give. The Adeco Group said it's 5 lines up from the bottom. For example, if a major client of the Adeco Group, do you have that? If a major group of the client of the Adeco Group were to terminate a single contract for Adeco Group services across a number of countries, then that could very well lead to circumstances triggering an extraordinary meeting in the light of collective redundancies being announced by local managements in 2 countries, directly a result of one single transnational issue, namely the termination of the contract. So this isn't a construction which makes the scope of the EWC vanishingly small. I mean, you could imagine that a multinational that employs Adecco in more than one country might make a decision which terminates the contract in the whole of Benelux, for instance, which would be a transnational issue. Or the multinational might terminate in the UK, but be very happy with its service in all the other countries, which would be just a national issue. Paragraph 41 turns about the rationale for the proposals, but let's go through at length the analysis. We get to page 1, 2, 3, which are the considerations. you'll see there, paragraph 58, that the Swedish and the German proposals were not time barred. The other two were time barred, and the appeal on that was dismissed by the EAT. The different reasons for redundancies are set out in paragraph 58. Over the page, paragraph 60 is the conclusion, which was not to accept the employer's submission that clause 514 is confined to situations where collective redundancies share a common rationale. That wasn't the entirety of the employer's submissions, as you've seen from before. That was one of them, and a principal one. But if you go to the bottom of that page, 2 lines up, it's irrelevant, says the CAC, whether to use the words of the employer's submission. The proposals in Sweden and Germany are separately formulated in different countries in light of unrelated national circumstances, or otherwise for country-specific reasons. The panel does not consider it a barrier to compliance with 514 that each country may be acting autonomously when proposing collective redundancies. There's no requirement the collective redundancies referred to in clause 514 should be proposed, approved or coordinated at a central level or any level beyond that of the individual country. Answer, well, that's what the scope paragraph 2 of the EWC agreement says expressly. It's what the directive says expressly. It's all about, transnational is all about something that's either coordinated at central level or coordinated at a level beyond that of the individual country.
So where does it say it expressly in the directive, just for my note?
At recital 16.
But didn't we go over this? It's not to do with the proposal, because that is very open to manipulation by the parties. It's to do with the substance and the effect of. So you might say they're firing at the wrong target here. I haven't quite got the scope bit of the agreement in mind, but didn't we cover that it's not really to do with the proposal, it's to do with its consequences?
Well, does the proposal concern 2 or more countries? So
yeah.
Does the proposal have consequences in 2 or more countries? And the answer here is, well, they say no. It doesn't matter.
They say it doesn't matter.
It doesn't matter. And then what they say, of course, realising that's a problem, how does Adecco in UK know what Adecco in Germany is doing? How does Adecco in Germany know what Adecco in Sweden's doing? Unless they are looking over each other's shoulders. How does the Adecco know that there's an obligation to go and meet the EWC? Because these different things are happening and they're not coordinated, they're not linked. What the CAC says is the responsibility of the employer to establish any necessary reporting mechanisms to ensure its obligation to convene an extraordinary meeting can be met. So that means that effectively it's requiring a business which decides to operate in a decentralised way to have some sort of reporting mechanism so that Adecco Sweden knows what's happening in Adecco Germany and so forth. It's completely unworkable and burdensome.
Is it?
Words of the directive.
Let's assume a Belgian redundancy situation that the employer doesn't think affects Luxembourg, but that objectively speaking does affect Luxembourg, and there may be consequences for the employee numbers or something, some potential consequences.
How would the employer not know? If either the employer
may be acting very myopically, there'd have to be some mechanism. If the EWC comes to the employer and says, hold on a minute, you need to have an EGM, that this has the potential. Is that so burdensome? Why?
Because it effectively doesn't allow a business to operate as it wants to in a decentralised way. It requires effectively.
But you've got to have an EWC level dialogue
for transnational matters. You don't say
collective
everything.
redundancies and acquisitions and relocations. So if you've got to have it there anyway, why is it so burdensome in a situation where whatever the employer thinks, there is, objectively speaking, a potential effect in another member state?
Well, two answers. First of all, because it doesn't need to be burdensome in order to work, because it's the wording of the directive, the wording of the agreement says it's not in scope. So effectively, even if it was completely unburdensome, it's not in scope.
That's
on
a
the
different
agreement.
point.
Secondly, it is burdensome because effectively it requires a employer to set up a reporting mechanism so that national issues, which are the exclusive responsibility of the national consultation body, are turned into, by this spurious mechanism, into transnational issues, and then you need to create a reporting mechanism so that all of the countries report in events which might have, or just domestic events.
But we've got an example here where all that happens is the Works Council say, we think these are all related.
Yeah.
We think it's all about COVID, and that you're not thinking strategically enough about the subsidies that are available in one country, or COVID allowances, or whatever it is.
But that would work. That would work fine. That example, if that was raised by an employee representative or another, and the employer said, "Oh, actually, these three countries are doing something."
Yes. So we'll have an EGM.
They'll have an EGM. So in those circumstances, but then you'd have the linkage. Then they would be related.
Well, you'd have to explore whether there was a linkage. The union thinks there is. The employer thinks there isn't.
If there isn't, there's no meeting. And if the employer's wrong, then they're in breach.
I'm just cavilling at your suggestion that it's so burdensome. I understand the scope point and I understand the construction points, but
creates
the idea that this is so burdensome is difficult for me to swallow.
I don't need it, and what I do say is that a company such as Adecco, which has 60 different businesses in 60 different countries, which deliberately organises its business in a particular way, the directive does not place requirements on it. It deliberately says national and transnational should be delineated. It expressly says that there shouldn't be a burden, additional burden. Effectively, it's protecting, to a certain extent, the national. Then the CAC effectively then puts the cart before the horse by dealing with clause 5.1.4 first, and then only going afterwards to the crucial thing, which is the gateway, which is clause 2, and then it gets that wrong, the reasons set out. It only deals with clause 2.1, doesn't actually deal with the definition of gateway of transnational at all in clause 2, and does, as the EAT does, gets the definition of staffing levels of the single country.
Sorry, where are you looking at?
Top of page 128.
Top of page 128.
So, and you've had my submissions, staffing levels of the single country are expressly excluded. And it said we can't be expressly excluded because that would take it outside of collective redundancies, and collective redundancies are included. Well, of course, that is completely circular thinking. Only you shouldn't have thought that collective redundancies are included and then go back to the scope and say, oh, well, the scope can't be right. You look at the scope first, and then you say, we don't even get to extraordinary meetings and collective redundancies. So circular thinking entirely by the CAC. So that's the CAC decision. The Employment Appeals Tribunal decision judgment.
Sorry, can I just go back one step on this collective redundancies point, which I think ends up not amounting to very much, but that you could have collective redundancies of 2 or more countries which were transnational because there was some effect by linkage, and you could have collective redundancies in 2 or more countries that were not transnational because they came for different reasons. So that was a false dichotomy.
Yes. And the crucial question is, does the proposal for collective redundancies in country A have knock-on effects in country B? Or is it one proposal, country A and country B? Well, is there a link? Are they related? I suppose is another way of putting it. Tribunal, the CAC and the Employment Appeals Tribunal says it doesn't matter if they're unrelated. I say it's absolutely key whether they're related, because related, two issues in two different countries which are related can only properly be informed and consulted at a European level. Because nationally, the fact that they're related doesn't cut the mustard. So I can go straight to the core parts of the Employment Appeal Tribunal decision, and that is the beginning at page 65 of the core bundle. You'll have seen that the EAT's conclusions contradict the purpose of information and consultation at EWCs as set out in the recitals. So the EAT doesn't take the recitals in as a factual matrix. The EAT says, well, I rely on recitals because it's not in the agreement. Well, that's not to do an investors' compensation scheme proper contractual analysis. You start with wording, of course, but you must read the wording in its proper context, and the context informs that wording. It wasn't right for the EAT to dismiss the recitals as being something that didn't affect the background context for the proper construction of the contract.
Can I just ask then on a question of information really on the supplementary bundle, page 12, the wording, the collective redundancies, does that feature at all in the directive or recitals anywhere? Where did it come from, as it were?
I think that relocations, collective redundancies and acquisitions,
Comes from the subsidiary requirements.
which are
paragraph
subsidiary
8 of
requirements
Schedule
in
18.
the directive and then subsidiary requirements in each national. So
It's
I take you to
It's page 90 of the authorities bundle in the regulations.
yes, I'm just looking at it's page 14 of the authorities bundle. 1414.
Thank you.
Sorry, just took me a moment to get there. And you'll see the subsidiary requirements of the directive at paragraph 3 at the bottom of the page. It says, where there are exceptional circumstances or decisions affecting the employee's interest to a considerable extent, particularly in the event of relocations, the closure of establishments or undertakings or collective redundancies, the select committee, or where no such select committee exists, the European Works Council, shall have the right to be informed. It should be the right to meet, request, and so forth. So effectively,
And that's replicated word for word at paragraph 8 on page 90 in the regulations.
in the regulations.
But the wording which significantly affect existing Adecco obviously is specific to this.
It's specific to
employees in each of the at least 2 EEA countries. That's from the negotiation, as it were.
It is. Well, it's from Article 1.4, which is the scope. Effectively, it puts the scope into that paragraph again. So the subsidiary requirements talk about collective redundancies being something that may be an example of an exceptional circumstance, or in this agreement, an extraordinary meeting. But I've taken you to Article 1.4, which is what is collective redundancies which might fall within the scope. It's collective redundancies which concern 2 or more countries. And these collective redundancies only concern 1 country each.
Thank you.
Of course, the EAT judgment, if I take you to the key passage, the judge says, and my reasons are as follows, at the top of page 68 of the core bundle. And hopefully I can go through these quite swiftly now. You'll see why I've said that the language of the agreement...
What was, just in a sort of brown note, what was the gloss he was rejecting?
That a decision must be taken in another member state. It must... So, paragraph 84. Requiring the relevant decision to be taken in another member state, as it put it, affecting employees in at least two.
But you're not saying the decision must be taken in another member state now. You're accepting that it could just have effects, but there must be some relationship between
the decision is taken in a member state
two member
other
states.
than the one that it has the effects. Yeah.
Well, it doesn't have... Isn't it about the effects, the substantive effects or consequences must be felt in two member states?
Yes. But if the effects are felt in two states, then as a matter of logic, the decision is taken in a state other than the ones that it...
So you are contending for that?
Yeah. I mean,
Not necessarily, no, sorry to pick away, but if let's just postulate, I don't know, Italy and Belgium are affected, you could well be a decision maker in Belgium that it has a knock on in Italy. So this formulation
Absolutely
isn't quite right.
And so as far as the Italian...
The Italian would say it was made...
This decision would
the
take
Belgians
another
would
state.
say
Belgians
it's national.
Belgians wouldn't, but it's
No.
still, as long as there's some workers who would say, this decision has been taken not by our boss in our country, but by somebody else, and therefore we've been denied the right to be heard. There's no point talking to our boss, because our boss is not the real decision maker here. That's why.
So is this the formulation you're contending for? I just want for my note to be absolutely clear what you're saying is the predicate.
I thought we'd moved away from this a little bit.
I thought we had
Yeah.
too.
Yeah.
I'm happy to go
Where we've taken...
directly where we have spent the last hour, which is Article 1.4, and it has to be a proposal which concerns two or more countries.
And you read concerns as including effects,
Yes.
as consequences.
As the recitals tell us, and indeed as the some CAC case law has come to that conclusion as well. So, looking at the EAT decision, so that's why the answer to paragraph 85 and my inferences from recitals. Paragraph 86, I've said to you why it's absolutely wrong as a matter of industrial reality to say that redundancies will all inherently have knock-on effects. That's just a complete factual.
They may not.
They may not. And if they do, it's transnational. If they don't, it's national. 87. What the EAT judge does there is only uses the word staffing levels. But of course the expression is staffing levels in a single country, staffing levels in the single country. So again, it puts the cart before the horse because one looks at the scope before you get to the effective redundancies. And it's absolutely staffing levels in the single country is staffing levels where they go up or down. It can't possibly mean how many workers to hire in the first place, not whether to dispense with some, and if so, how many, which ones. As a matter of industrial reality, the time when this EWC agreement was made, there were workers in the various countries. And staffing levels in a single country would be about whether those staffing levels in those countries would go up or down. Couldn't possibly mean, and I don't know really what it does mean, how many workers to hire in the first place. Anyway, paragraph 87, I say, is a little difficult to follow. Paragraph 88, he's absolutely right that the effect in each of the two countries need not be the same, and there could be different effects in one country and another, such as indirect or knock-on effects, but there has to be indirect or knock-on effects. There has to be some relationship between the two. They can't be unrelated. I think even on his analysis, there needs to be some direct or indirect or knock-on effect between Sweden and Germany. And in this case, there wasn't. 89.
So it doesn't have. Do you agree with what he says in 88? But there must be indirect or knock-on effects, even if there isn't a common cause, or.
There could be a common cause, or there could be a
might not.
There has to be some relationship,
Yeah.
some causal link between the two proposals. So I agree with, but I say that argument undermines the EAT's rationale. Fifth, and importantly, difficult to secure enjoyment of information consultation if it could be defeated by requiring local management. Well, that's to forget that the most important information consultation takes place locally, takes place in collective bargaining. It's almost as if the judge had in mind that if you didn't do it at the EWC, these workers wouldn't have a voice. Well, the opposite is the case. The national bodies are often the much more powerful ones because they're close to the decision maker and because often there's collective bargaining involved. Paragraph 91, the judge says that it shouldn't turn on nuances in the relations between local and central management. A local manager may be instructed by a central manager to effect redundancies. Well, if so, it's transnational.
Well, he's instructed is the easy case. It's the other cases where it's done less openly, isn't it, that he's concerned about?
Absolutely, but that's just a matter of, I mean, it's effectively, we can't take the facts out of cases. And either something will be, as Professor Warnock says, in substance, transnational, or it won't. And the question is, and if it's just authorised, if the central management just permits the management to do it or not, then who does the worker need to speak to have proper information consultation? He needs to speak to the person taking the decision. The fact that somebody else authorises me to take a decision, if it's my decision, then I'm the person who they can effectively inform and consult. There's no point talking to the person who's authorised me, because they'll say, well, no, it's not, I've authorised it. It's nothing to do with me whether they do it or not. That's a matter for them in that country in their circumstances. I can't give you anything more. So it's about talking to the right person. I say this case comes down to. And so that's why I say it is, paragraph 92, important to analyse the interplay between central and local management, because EWCs and TISA and the directive is all about making sure that employees are not cut out from speaking to the right person. And then the AT says at paragraph 93, it's true that on the AT's interpretation, a transnational issue can arise without the need for any real nexus between the two sets of redundancies. In oral argument, I mentioned the example of a factory fire in Bulgaria, leading to redundancies in Bulgaria, occurring in the same week as an earthquake in Portugal, leading to redundancies in Portugal. I accepted Mr. Adair did that the extraordinary meeting would have to be convened because the matter is transnational. Mr. Burns said this would be inconvenient and burdensome. I think the point's overstated. In such a case, the extraordinary meeting, no doubt, can be conducted remotely. Well, of course, EWCs absolutely will like to have it in an in-person meeting if they possibly can, because in-person meetings are effective and everybody gets to go to a hotel. And
well, they may like it, but it may not be practical.
Yeah, but it's often insisted upon by EWCs, and they complain if it's not given, and there are complaints about that.
We can't.
But we can't assume. We can't assume it's going to be, no doubt, connected remotely. There may be complaints if it is conducted remotely. And that would be very short. Everyone would recognise that two separate events are not linked, knock-on effects unlikely to be followed up at national level. So what he's saying is, we must, even though the directive and the regulations and the agreement says that there must be a clear delineation between national and international, and where it's national, you don't have something that's international. He said, oh, we'll have a meeting anyway to find out that it's just national, and then everybody can, the meeting will be very short. That is not a way to analyse industrial relations. I mean, that is the way to create havoc in industrial relations.
Well, he's given a more permissive reading to the idea of transnationalism, because as I see it, that has the virtue of transparency and legal certainty. It's this para 92 point, which I'd like to hear a bit on, because there is a problem with what you're saying, that it's all a bit murky where the line is, and there is the spectre of employees not being given information that they'd like to have.
But if that's right, that's where the directive requires there be effective remedies, so that it doesn't happen again. That the employees can complain to in that.
But it's a sort of chicken and egg, because if it's a bit of a chicken and egg, isn't it? Because if the employees don't have the information, it's very difficult for them to legitimately to complain that they haven't been given information they ought to have been given, because they don't know what they don't know.
Well, but they never know. They're never in a known. They're always in a known unknown situation, because the EWC reps are often the same reps as the national reps, or they're talking to the national reps. So EWC reps will always, in fact, have information from Sweden and Germany, can talk to each other and can work out whether they think that the employer has got it wrong.
But what they can't do is come to the employer on your argument and say, look, there's something going on in Sweden, there's something going on in Germany, we want to know a bit more about this, because the employer, on your argument, just as Adecco tried to, folds their arms, writes them a letter, says they're nothing to do with each other, go away, and all they can then do is whatever they have to do to take enforcement action against you. Whereas what Mr. Justice Carr was saying is, look, there's a really easy way through this. You call this EGM, you give them the information, and if there's really nothing there, that will be out, and we've solved it.
So that's to say we consult on matters which are not transnational, which might, in the employee's subjective mind, be transnational, in order to decide whether they are transnational and then discount it. And effectively, all information and consultation is infected by the slight uncertainty that you're mentioning. All national information consultation is. Unions will always say to employers, are you telling us the full story? Are you telling us enough? And then employers will tell them often what they think they need to do and no more. Sometimes employers will give more, but effectively that is the industrial relations reality. There's nothing different about EWC, international, transnational information consultation from national in that respect. But the idea that you can fix it by having a extraordinary meeting just in case. The problem is this, that in a global firm like Adecco with 21 countries and 18,000 employees, in January there are likely to, well, as we see in this case, there are likely to be some redundancies or an acquisition or relocation somewhere in the 21 states in January, and somewhere in February, and somewhere in March, and somewhere in April. The EWC reps would not actually get any work done, because they'd always be meeting in extraordinary meetings. They wouldn't be able to get on with their careers because they would be called in just in case. I mean, that would just be completely unworkable. And in a company like Adecco, it is not, I mean, it's not at all hyperbole or unrealistic to say that something along this sort is going to be happening every month or so, at least every couple of months. Extraordinary meetings will become ordinary.
Can I just ask one question, following up really from the point about where the wording in the actual agreement come from? I mean, it seems modelled, but is obviously specific to this particular point.
Yes.
Could what the objective bystander conclude, look, obviously if you have collective redundancies in Sweden and collective redundancies in Germany, someone might subjectively think they're related. We're going in this agreement to say, fine, we're going to have the EGM in there. It may be a short meeting for the reasons given by Mr. Justice Carr, but everyone will know where they stand rather than boiling resentments, which is always the antithesis of good labour relations. And therefore, you as the employer and these as the employees have agreed this is the situation. We'll have the meeting, it's going to be a very short one, or it might be longer because, in fact, it might have been COVID related, although on the findings of fact wasn't in this case. What would you say about that?
I'd say that in January you would have boiling resentment because the meeting would turn up and the employers would say this can be a short meeting, these are plainly not connected. The employees would say, no, well, that's not, we're here now, let's hear about it. And in February there'd be boiling resentment because the employers would say these are not related, and the employees would say, well, we're here now, let's hear about these things. And in March, it would descend into, I mean, in reality, it would not help industrial relations at all, and it would not be good information for information consultation at a transnational level. Effectively, you just have disputes in reality, sadly. I mean, EWCs are not, in some multinationals, they work really very, very well indeed, but not in all. And it's often personality driven. Personality of the employer, personality of the union reps. It's political, the political situation at the time, where the trade union movement is motivated by things other than purely the specific company's interests. Economic, where the employer is not sharing things because it feels it's in a tight situation. None of these things I say apply to Adecco. I put them very much as generalist points. But industrial relations in many countries has ups and downs. And I'm sure to a certain extent you can take judicial notice of that.
Thank you.
So that's the decision of the EAT, and I think that my then other points have either been covered or I can cover them in 5 minutes, which I'll have to ask for a indulgence. But we have had a useful discussion, I hope, on the points as we've gone along. The previous CAT decisions are dealt with in our skeleton, Haynes and Vesuvius and Prince's Group, and I'll just direct you for your note to page 112 of the authorities bundle, 164 and 205, and as my lady Justice Simler said, so you're not bound by these, you're the Court of Appeal, but you'll see that in those 3 cases, the appellant's construction of what's transnational has been accepted as being conventional by other CACs. I've given already examples. We've talked about the fire and earthquake examples, and the point on the fire and the earthquake is the agreement cannot intend to call a pointless meeting. And in some ways, the EAT has said, we'll call a meeting. It will be pointless because the meeting will very soon realise that it doesn't need to exist. But the agreement cannot, the intention of the parties, objectively ascertained, cannot be that it's intended to call pointless meetings. It has to be about meetings that there's a European level or a transnational level issue to be explored that otherwise would not give the employees a voice.
I mean, it's possible to imagine a situation, isn't it, or perhaps it isn't, where on the face of it, 2 different redundancy decisions are made, one in Sweden and one in Germany. But to all intents and purposes, the unions or the EWC thinks that, in fact, there is a single decision that's been taken, but it's been salami sliced, and the single decision does have effects in 2 member states. And I guess this comes, this follows from what my Lord put to you. In that situation, on the face of it, it's not a pointless decision. This is a decision to implement collective redundancies in 2 member states that will significantly affect employees in 2 member states, with the potential, at least, for it to be a transnational issue. Is that a pointless EGM?
Employers and unions know what has cross-border effects because it's commonplace. For instance,
well, this does have cross-border effects. It's just, it may be that it's one decision with cross-border effects, or it's 2 decisions that are totally independent but have coincidentally occurred at the same time.
Yes.
And without exploring it and understanding the structure and who made the decision and whether there is a devious management situation occurring.
Yes. Well, that's what happened here. The EWC said, we think these are linked.
Yes.
The employer gave an explanation saying they're not linked. That actually was right. CAC said they're not linked. At that point, the EWC should properly have said, I've got an explanation, it's actually right, left it there. We're only here because they didn't. They unreasonably kept on saying, oh, actually, they are linked. But the answer I was going to give is that employers and unions know things that have cross-border, transnational implication, because you have HR, and this happened in Adecco, you have HR and finance in one country, and HR and finance in another country, and the employer suggests, well, it makes more sense for us to have one shared service centre and for HR and finance to be dealt with in one location. That's going to have impacts on redundancies in the other locations. Or there's going to be a relocation of work. Wouldn't happen in Adecco, but in the car manufacturing. So I think what we shouldn't do is try and imagine that there could be two coincidental national decisions which somehow would have some hidden transnational. That in my submission, is unrealistic, because if I'm employed in a business in the UK, and my workers are there, I know whether that I'm working with employees in France as part of my wider team, or I'm working as purely as a national worker, only dealing with UK people. And if that team is then impacted by collective redundancies, I know whether I'm part of effectively a shared cross-border team, or I'm a domestic team. The workers know, because they know who they're dealing with. They know who their colleagues are. So I think the idea that the judge's, EAT's idea that somehow it could be some sort of employer would know, but the workers wouldn't. Well, the workers are doing the work. They know whether they're within a wider sphere, which is cross-border. I've dealt with then Mr. O'Dare's submissions as I've gone along. Why it's addressed by the scope, why it's addressed by single staffing levels of a single country, why the textual reason is because the scope is the threshold test. Paragraph 36 and 37, I will just say this of Mr. O'Dare's skeleton, is potentially an attempt to reopen the facts. He talks about...
Sorry, paragraphs?
36 and 37 on page 34 of the core bundle. Prima facie unlikely that many multinationals operate a model where the parent company makes executive decisions, but there may be ones where it doesn't make centralised decisions, but it's powerful, even determining involvement. Well, that's reopening on the facts. This case, in Adecco, there's no influence or determining involvement, which needs to be looked at. In this case, the CAC said these were unrelated. Paragraph 41 of page 35, Mr. O'Dare says that this leads to a narrow information consultation focus. Well, I've told you why. The vast majority of worker consultation, quite properly, will be local and national. It only needs to be supplemented where it's a genuine transnational reason. So it's been pointed out that the 10th of June meeting was not an annual meeting, that was an additional meeting, but the annual meeting was in November 2020. Apologies for that.
Right. So annual meetings are in November.
Or at least was in November 2020.
Yes.
Was the June meeting not now being an annual meeting? Was it an extraordinary meeting or not?
I think it was...
Sorry to ask.
Yes, of course. So because of COVID, it wasn't called, at the request of the workers, it was called by the employer because of COVID, knowing that that was a global stroke transnational issue. So whether it didn't involve collective redundancies or relocations or acquisitions, so it strictly wasn't within the agreement. Effectively, it was an additional meeting for the benefit of all parties.
And I imagine at the time, because that had to be remote, because of, yeah.
I think that was remote because everything was remote, of course.
Inevitably, yeah. Thank you.
maybe I'll deal with those points in reply if Mr. Adair.
Thank you very much. Well done. Mr. Adair.
May it please you, my lady, I wish to place my submissions in response within the context of a remark that you made, my lady, right at the end of Mr. Burns' submission, beginning Mr. Burns' submissions. And you said something like this: we have to have a system applicable to this case which is fit for purpose for the real world, not one which sounds attractive and elegant necessarily in this learned tribunal. Mr. Burns's submission, which I'll set out his, as I understand, his developed understanding later, has the attraction of elegance and simplicity. There must be a decision, a proposal in one country which has effects, consequential effects in two others, or that country and one other. In a world of perfect knowledge, I shall submit, that would be very attractive. But it is not fit for purpose for the world in which EWCs really live. With that introduction, I want to take you to the text of the agreement itself, which is found in the supplementary bundle. Sorry, I just lost a document from my screen. There we are. Page 6 of the supplementary bundle. And we begin with, appropriately, Article 2, scope.
I'm in the agreement. Are you in the directive?
I'm in the agreement as well.
Oh,
Page
Page
6, supplementary bundle.
yeah.
It's got organisational efficiency. Is that the page?
Scope is on page 4.
Scope is on page 4. I do beg your pardon. I thank you for your patience. Scope is, as far as material to this submission, set out in a long final sentence. Matters are considered as transnational where they concerned or have potential effects, at least on two undertakings, and you can read the rest.
And you agree with the typographical corrections made?
Yes.
Concern or have, yeah.
And the key word to which I wish to draw your attention is matters. It does not say proposals. Like every good advocate, Mr. Burns elided every time the matter came up from matters to proposals. And it's my submission, the very relevant consideration for you in evaluating his submissions is this: why did the agreement not choose the word proposals, and why did the directive in the relevant parts not choose the word proposals, if that is what had been meant? It is meant in my submission to indicate a considerably broader concept. In particular, whilst definition of matters may be difficult, in my submission, it covers things like redundancies. events in the real world which are clear and transparent to EWC representatives and local reps. They can see when redundancies are occurring, whereas they cannot see when...
But it's too late, isn't it? If you have to wait till the redundancies are occurring, then the information and consultation is pointless. Is it? Does
Well, you
have to be at a formative stage.
Indeed, when the redundancies are proposed.
So it's got to be a proposal.
Yeah, fine. Yes, yes, but not at. You won't be able to tell, and this is the point, whether the proposal emanates from solely local reps or whether it emanates from something broader.
But it must be. It can't be the redundancy. It must be something much earlier.
Yes, and that is clearly right. That is clearly right. Going on to 2.1, further down the same page.
Before you leave that, can I just ask you about, it's only because I just noticed it now, in the penultimate line it talks about potential effects rather than actual effects.
Yes.
Does anything turn on that?
I think it does, in this sense, that it indicates the breadth and reach of the agreement, because the word potential indicates that it might be satisfied in which there were redundancies in country A, but only potential effects in country B. There might be an unease, understandably, on the part of representatives about potential effects in neighbouring countries. Going on from there to 2.1, local matters and issues. These are the things that are excluded from the scope of the EWC. And the key phrase to be construed, because it's relied upon by the appellants, is staffing levels of the single country. And again, in my submission, the question is, why was that language used if the intent was to exclude collective redundancies? The phrase collective redundancies is part of the furniture.
But a collective redundancy that only affects one country will be dealt with at local and national level, won't it? You're not suggesting a collective redundancy that has no impact on any other than a single country. Must be informed and consulted on at transnational level, are you?
Well, subject to 2 points.
Yes.
The first is that there's the potential effects point.
Well, but if it only has effects or potential effects on a single country, that would be so. That's right. So that would be and that would be consistent with staffing levels of the single country.
Well, it would be consistent with it, but it would also be excluded elsewhere by not falling within the definition of Article 5.2. Yeah. You don't have to rely on this. You don't have to give an even broader reach to deal with that issue. Right. So if we go now to Article 5, which is on page 14, 13 and 14, goes over the page.
Well, we've got it starting on page 10.
Oh, I don't know how that happened. I do apologise. We have there the introductory clause. Extraordinary general meetings will be convened to provide information and engage in dialogue with the steering group on the following transnational issues where exceptional circumstances arise. And then in B, we have a text on which we, and indeed on which the CAC relied. CAC said effectively, well, this is simplicity itself. The introductory clause indicates that the following examples are transnational matters, and in the list we find what is set out at B, which, if applied straightforwardly, applies to this case, and indicated that the appellants were in breach.
So whatever the meaning of the directive, whatever the meaning of the regulations, they provide a floor of rights, but there's nothing to stop an agreement going above that and employer and union agreeing to something more. Is that what you're saying?
That is absolutely correct, my lady. Now, Mr. Burns, his answer to that, as I understand it, is this. Well, it's a mistake to take things too literally. He says that one has to read into that provision something along the lines of when, but only when, the redundancies are the result of a single decision in one state. And my difficulty with that, on the face of it, is simply that it reads into the text words which are not there and which could easily have been inserted by the parties if that is what they wish to do. Now, Mr. Burns' answer to that is, well, you don't have to just read it literally, you have to read it purposively. And he relies on various of the recitals in aid of the construction he proposes. As Mr. Justice Kerr observed, however, the recitals do not go only one way in this case. Recital 7 talks about the need for effectiveness. Sorry, I'll take you to those, my lady, if you... That's on, if I've got the page numbers right, page 2 of the authorities bundle.
Yeah.
And then in recital 21, we have a reference to the legal certainty required for the application of this directive. So, in my submission and being...
Just before you make the submission, what do you say about the recitals aren't... They're part of a purposive approach to the... or they're part of the context? How do they inform the true construction of the agreement?
They inform the true construction of the agreement in this way, that if the text is in any way unclear, then one may have resort to the recitals to elucidate and clarify that uncertainty. So my primary submission is it's just clear. My secondary submission is if one looks at the recitals, one can only but note that amongst them are the two that I have indicated. And so one can't simply, as in my submission to Burns did, point to the ones that support your proposition and say, well, that's that. You have to look at all of them. And it is a difficult task. You have to take into account all the recitals when coming to your conclusion as a court about the meaning. So that is, those are the recitals to which I've drawn your attention. And I just want to add something about the factual background. Mr. Burns said that the factual background are the recitals, full stop. And in my submission, the background includes those, but includes other things also. And I'd like to take you to page 49 of the core bundle. Sorry, it's 48, page 48, paragraph 49.
I've got paragraph 24 on page 48. Am I looking in the wrong bundle?
I've got paragraph 7 on page.
Yeah, which, when you say the core bundle, did you mean the judgment of Mr. Justice Kerr?
I meant the judgment of Mr. Justice Kerr, which I thought was in the core bundle.
It is in the core bundle.
Tab 6, page 43.
Page 4, thank you
What
very much.
paragraph? No, what paragraph?
Paragraph 49.
Paragraph 49.
Paragraph 49.
Which is page 58.
Yeah, thank you.
And from your reading, you will have read this letter, which was submitted in evidence to the CAC. And in my submission, this letter is very important because it was the evidence and the only evidence the CAC and this court had and have about how decisions are made in this multinational company. And I draw your attention to this because in my submission, one of the deep underlying flaws in Mr. Burns' case is this. He presupposes a binary categorization of decisions. According to Mr. Burns' case, there can be decisions taken at the centre which have company-wide effect. But equally, there can be decisions at the local level which have no connection at all with the centre. So decisions come in the one category or the other. And my submission is that that is, on the basis of the only evidence the CAC had, a wholly unrealistic.
Sorry, so which bit are you relying on? Because it does look to me as though it's quite binary.
Which
bit are you saying?
That I am saying that it is what this paragraph shows.
Well, which bit are you saying?
Okay. The group operates, first 3 lines, the group operates as follows. The Adeco Group headquarters is responsible for developing the group's strategy and for translating, in consultation with the countries, the the strategic objectives into local operation targets and country budgets.
Yes, and that would be a matter for the annual meetings. They'd inform and consult at annual meetings about that.
It certainly would be.
But then they go on to say, while the overall strategy and objectives are set centrally, local management must decide how to put it into effect.
Yes.
And that was the point Mr. Burns was making.
I understand, and I'll come back on that. The first point I want to come back on is just the role of the annual general meeting. The idea that these things will come up in the annual general meeting and be dealt with, as it were. With respect, that depends on the assumption, as I think my Lord Justice Dingemans said, that nothing happens subsequently to bring these things into question. And in this case, we have an extremely good example, the COVID disaster. Under those circumstances, dealing with COVID involved challenges to budgets and a reassessment of targets on behalf of almost every business. If in those circumstances, local management were to say, well, central management to say it's nothing to do with us, that would be wrong factually, because it was something to do with them in the sense that local management was operating within the parameters they had set. The parameters and budgets set by the centre continue to have an effect on otherwise local matters. For example, in the case of COVID, the obvious thing to do would be to seek variation of the budgets, which according to this paragraph is a central matter.
So although HQ doesn't ask countries to cut jobs and leaves it to them to decide on the composition and volume of the workforce, you're saying that the EWC should be able to look at the budget and say,
yeah,
there may be no need for the local level to cut jobs because the budget could be
varied,
in a different
or
way.
redundancies should be various reasons fall differently across different sites, as it were. But more generally, in my submission, the idea that once the budgets were set, local management were left to it. There was no discussion with the centre at all about how to proceed. In my submission, is an unrealistic assumption for which there was no evidence. Related to that is this point, and it comes from the mouth of Mr. Devious, as Harvey labelled the gentleman in question. One does not have to be unduly cynical to think that Mr. Burns's formulation places EWCs in an even weaker position than they would otherwise be. Because if matters are occurring and in, say, Germany and Sweden, or Germany and Hungary, or whatever, and the EWC says, well, we think this is a matter for collective consultation, Mr. Burns is correct. It is an answer for management simply to assert, no, these are local matters. So, it's nothing to do with us. on the formulation proposed by the EWC, once redundancies had occurred in 2 different countries, that would be a transnational matter.
But it's too late for information and consultation then, once they've occurred.
Proposed. I'm sorry, I'm using the wrong.
Okay.
Sorry.
Once they're proposed.
Yeah.
Okay.
If the EWC goes to management, management just may well say, well, it's just a local matter.
Yeah.
Whereas if the CAC's formulation is accepted, there will be discussion and debate, and it may turn out that it is indeed not something that can be discussed in an EWC, but it may not. There will be some exchange of information, and the EWC will be in a much better place to make its case.
Mr. Adair, is it part of your case that there's a grey area on some of these decisions?
Yes.
Because what you're looking at is potential effects, and that's quite a fuzzy concept, so that would you say that one of the failings in the appellant's case is that that the case postulates a black line where there isn't a black line?
The binary line, absolutely, yes, I do say that. And Mr. Justice Kerr was quite taken with that point in his judgment as well, that there are a whole spectrum of interactions between the centre and the locality, and that on Mr. Burns' formulation, it's only at the extreme left end, as it were, when there's a conclusive decision taken by management at the centre, that the EWC can come into effect. Mr. Burns said, well, employees just know, the EWC reps just know when it's a transnational matter because of their experience of ordinary working life. With respect, that's an assertion without foundation and which seriously underestimates the power of management to control the flow of information. It would be wrong in my submission to make it a part of your decision that employees just know when a matter is transnational. In my submission, they just don't, or not necessarily, and that's why Mr. Burns' formulation, together with the spectrum of decisions which may happen in a multinational locality interaction, is so key. Drawing this to a close, this part of it to a close, Mr. Burns, sorry, I drew your attention earlier to the principle of effectiveness and certainty. And I really want to underline those 2 principles, particularly the principle of effectiveness as it applies to this case. The formulation, the structure for which Mr. Burns has sought to advocate is not fit for purpose to secure an adequate scope for EWC consultation and information. As my lady has said, it's very important, as Mr. Justice Kerr thought, to take into account a spectrum of interactions between management and locality. In my view, my submission, Mr. Burns's formulation, whilst attractive in debate on Chancery Lane, does not set up a workable scope for EWCs generally, or for this EWC in particular. to that, I would add this. It seems to me, though you'll tell me I'm wrong and your notes will determine it, that Mr. Burns was somewhat driven back by your questions from his initial position to his subsequent position. If you look at his skeleton, the position is that there must be a decision in one country affecting two others, or that country and one other. Whereas he later retreated to the position that there has to be some kind of link, unspecified. But in my submission, that won't do, partly because it is unspecified. We don't know, because he's not told us, what the link is. And in my submission, what he was actually doing was smuggling back in, through the back door, the requirement for a single decision to link what happened in the two countries. In my submission, his final resting place, under questioning from the court, indicated that the weakness of the overall argument. Those are my particular submissions in response. I just want to check, because I did make some notes on in particular.
Well, we're clearly going to go over to 2 o'clock. Is that a convenient moment, and you can check and say whatever you wish to say after the short adjournment?
Thank you, lady.
Thank you.
All right.